In this podcast, we'll be talking about the important case NAV Canada. NAV is important because it shows us the evolution from the time we had Stilk and Myrick to now, and it brings us to a place where we can have the doctrine of economic duress coexist with the doctrine of consideration without limiting certain agreements that are in fact voluntary. Here's a summary of the case, and here's a chart showing the relationships and the transactions between the parties. I'll give some more detail here. You have the minister, and you have NAV Canada and Airport Authority. The minister has certain responsibilities, and NAV Canada is a corporation that was incorporated specifically so that the minister could assign it some of his responsibilities. And then you have Airport Authority, which is another corporation, and the minister has assigned the rest of his responsibilities to Airport Authority. So the minister has no more responsibilities in relation to this case, to this issue, and that takes him out of the picture. The contract is between NAV Canada and Airport Authority. The contract is called the ASF. The issue in this case was the agreement by which the Airport Authority promised to pay for the DME supported by consideration. Put another way, it's the same question we've been asking from all of these cases. Is there fresh consideration for the Airport Authority's subsequent promise to pay for the cost of the DME? What brings us to the topic of consideration here, or variation? Well, under the ASF, NAV Canada had the responsibility to pay for the DME. The agreement said that NAV would be paying, meaning if the Airport Authority was to pay for the DME instead, then the Airport Authority is providing something more to the agreement, so we would then have to find that NAV had also promised something more in return. That's what takes us to, is there fresh consideration for the Airport Authority's promise to pay the DME? Did NAV Canada agree to do more than it was originally bound to do under the contract? There are a couple of principles at play. First, something more provides the consideration necessary to enforce what would otherwise be a gratuitous and enforceable promise. So what is that something more? Also, you have the principle that the performance of a pre-existing obligation does not qualify as fresh or valid consideration, and therefore such an agreement to vary an existing contract remains unenforceable. And that's the rule from Stilk and Myrick. So how do we have the rule from Stilk and Myrick and then also reconcile it with the new rules today? Before we get into that, NAV Canada put forward a couple of arguments, and the court discussed them. So let's look at those. NAV Canada says that we did not breach the agreement, and that is the consideration that we provided. So does forbearance from breaching the existing contract qualify as fresh consideration? And of course the answer is no. So NAV cannot argue that the consideration it provides in exchange for the Airport Authority's promise is that it is not going to exercise its legal right to breach the contract. Public policy prevents us from using threats to breach a contract as valid consideration for the new agreement that was procured under those threats. The other argument is that, is a plea of detrimental reliance a valid basis for enforcing an otherwise gratuitous promise? And in this case, the argument would be that NAV would say, well, the Airport Authority agreed to do it, and in reliance on this agreement, we did a whole bunch of things. We built it, we extended it, we spent time and money on building the DME, and so therefore we relied detrimentally on the Airport Authority's promise to pay for the DME. This is distilled down. You're saying someone made you a gratuitous promise, meaning you didn't pay for it. Someone promised you something, and in reliance on that promise, You went out and did a whole bunch of things. So can you use that? Can you use your detrimental reliance as a reason for enforcing that gratuitous promise? This is an estoppel-based argument, and this is, we're going to be talking about promissory estoppel right after this unit. So keep this argument in the back of your minds, and we will get to it later. So back to the trajectory of this law. Because Stilken-Myrick is a rigid doctrine, the courts have developed ways to get around it. So before Williams and Rofe, the courts had a number of ways to circumvent its application. One of the ways that we looked at, one of the ways that we looked at was under the case for mutual rescission. So if you can find that there's mutual rescission, then there's a new agreement, then the new agreement will be upheld. So that was before Stilken-Myrick. That was before Williams and Rofe. You have this rigid rule. Courts don't like the rigid rule, and so they try to find ways around it. Then came Williams and Rofe, where the court accepted that the plaintiff had not undertaken to provide any additional consideration. But it didn't blindly apply Stilken-Myrick. So it confirmed the rule in Stilken-Myrick: a gratuitous promise remains unenforceable unless it's given under seal. So that's, remember, one of the exceptions to the doctrine of consideration. But the Williams and Rofe court also determined that where there is other consideration to support the agreement to pay the extra sum, that agreement will be enforceable. Now, what kind of consideration will suffice for that? And Williams and Rofe expanded our view of that. So it said where benefits are derived to each party to a contract of variation, even though one party didn't suffer a detriment, it's not fatal to establishing the agreement. Meaning, if both parties benefit from the agreement, it's not necessary that each of them also suffers a detriment. So if you have X paying Y more money for the agreement, X is suffering a detriment, which is the payment of more money, but Y is not suffering. Y is simply benefiting. Y is providing a benefit to X, which is a commercial advantage, but Y is not suffering a detriment because it's the same agreement. And in Williams and Rofe, they said, that's fine. You don't have to find that each one suffers a detriment. So since Williams and Rofe, the law has accepted this principle. And in comes NAV Canada. In NAV Canada, the court says that the doctrine of economic duress lessens the need for a, quote, rigid adherence to the doctrine of consideration. How is that? What does that mean? Well, it means that practical benefits accrue to the defendant as a result of the modification, meaning that the party clearly gains a commercial advantage from modifying the agreement. And that is enough. That is the practical benefit we're looking for. The court in NAV Canada concluded that under English law, it's no longer necessary to look for a detriment because of Williams and Rofe, meaning that the doctrine of economic duress can be used to curtail the new practical benefits commercial advantage. So if we find that there's economic duress, we're going to find no consideration. Otherwise, we're going to uphold the variation if there's no economic duress and we're seeing that the parties are practically benefiting from this variation. It's important to know that the court is not changing the common law doctrine of consideration. It is simply saying that the rule of Stilken-Myrick should not be regarded as determinative on whether a gratuitous promise is enforceable. It shouldn't be the final decision. There are other factors. The rule of Stilken-Myrick is important, but it can be harsh under certain circumstances because it fails to take certain realities into account. So what are the problems with it? The problems are the rule is both over-inclusive and under-inclusive. It's over-inclusive because it captures renegotiations that are induced by coercion as long as there's consideration for the modification. Meaning, as long as there's consideration, the agreement will be upheld, even if that agreement happened to be induced by coercion. The rule of Stilken-Myrick does not prevent that agreement from being struck down. rather, it doesn't prevent that agreement from being upheld. The rule is also under-inclusive because in cases where there's no consideration, then it will find that those agreements are unenforceable, even if they were voluntary, even if there is no duress. Meaning if there's no consideration, but both parties willingly and voluntarily entered into the agreement, the rule will strike down that agreement. It captures situations where there is no concern of duress, and it fails to capture situations where there might be duress. It is a rule designed to counter duress by finding duress on the finding of consideration. But the two don't necessarily go hand in hand. There can be duress and consideration, and no duress and no consideration. Also, the reality is, existing contracts are frequently varied and modified by tacit agreement in order to respond to contingencies that the parties may not have anticipated when they first entered into the agreement or when they were negotiating. So as a matter of commercial efficacy, it is necessary to adjust the parties' agreements from time to time, and the law has to protect the legitimate expectations of those modifications. So back to NAV. The court determines, again, that in law, a variation to an existing contract, unsupported by fresh consideration, may be enforceable, provided that it was not procured under economic duress. So then it considers the doctrine of economic duress. And it says that the party seeking to enforce the variation must establish that the variation was not procured under economic duress. So what does NAV Canada have to prove? Well, it has to prove that it wasn't putting duress on the other party. It was not acting, the other party was not acting under duress. How do you establish that? Well, if you look at what happened here, first you find that NAV exerted pressure to obtain what amounts to a contractual modification to the ASF, and the airport authority was left with no practical alternative but to capitulate to NAV Canada's demand. So there you have these two elements. They've both been shown. But that's not necessarily the end of the analysis. After you establish that, you have to see whether the airport authority consented to the variation notwithstanding the circumstances in which the promise was made. So we know the promise was made in those circumstances where NAV Canada exerted pressure and the airport authority did it. It was left with no practical alternative, and it seems to not have been wanting to do it. That's not the end. If you look back to the reason that we're worried about a promise not being supported by fresh consideration, the reason is that the consent was lacking. That's the concern, that there was no consent for that transaction. So no fresh consideration creates an inference that consent is lacking. And we know that it was lacking in this case. We know that because there's a confirmation in the phrasing of the airport authority's letter to NAV Canada. Quote, "Your arbitrary deadline has now forced us to make funds available under protest." And the court said even if those words had not been used, there's nothing in the record to indicate that the airport authority had acquiesced. So maybe it was not in agreement at the beginning, but then it just accepted it. And that would amount to acquiescence. How do you find acquiescence? Well, you might find a case where the money was paid and then the airport authority just did nothing. So everything just fell into place and nobody ever mentioned it again. That would be acquiescence. However, in this case, you have the airport authority refusing to pay from the very outset and not deviating from the position now that the coercer has fulfilled its contractual obligations, which is it has built the DME. So at no point did the airport authority change its position. And at no point did the airport authority therefore acquiesce to what happened. So you see that there's no consent when the decision was made, and that never became acquiescence. There was always no consent as the transaction was occurring.